Welcome to the course on medical law. This lecture will be about admissibility of forensic evidence. The concepts covered in this lecture are evidentiary value of medical opinion, forensic evidence, inconsistency between ocular and medical evidence, contradictory opinion between doctors, medical opinion as to the time and cause of death, medical opinion on age of a person. The keywords of this lecture can be seen here. The medical evidence presented by the prosecution is highly corroborative. It demonstrates that injuries might have been caused in the manner described by an eyewitness, and the death may have been caused by the injuries, so that prosecution case is consistent with the facts provable by medical evidence, and then the eyewitness should be believed. So, it may be argued before the court that medical evidence that is submitted under the Evidence Act before the court is validating the statement given by the eyewitness. Eyewitness has seen something which he has described before the court through a testimony. So, eyewitness account has already shown before the court that the injury or the death might have been caused due to the blow of a sword or any other object. The medical opinion is used to prove that the eyewitness account is accurate and correct information regarding the facts that has happened. The defense can also use medical evidence to argue that injuries could not have been caused in the manner described by the prosecution, or that death could not possibly have been caused in the manner alleged by the prosecution, and if it can do so, it discredits the eyewitness. So, take for example, an eyewitness has come before the court and given a statement that he has seen a person attacking another person. While describing the incident, he has told that a particular object was used to attack the person. So, now it must be proved that the injuries on the second person was caused due to the use of the instrument by the first person. So, now the injuries should have to match the medical opinion. So, medical opinion could be used to see whether the eyewitness account is matching the description of injuries given by the doctor. A medical witness is neither a prosecution witness or a defense witness under section 45 of the Evidence Act, which is now replaced by the Bharatiya Sakshya Adhiniyam 2023, and the corresponding section is section 39. Medical witness are to be called within the limitations of science to assist the court in ascertaining the truth, which may or may not benefit the prosecution or the party summoning him. Now, let us see one case, Vishnu versus State of Maharashtra, which is a Supreme Court decision in 2006. In this case, the Supreme Court said that the medical expert's testimony is merely advisory in nature. A medical witness' judgment does not have to be the final word on the matter. The court will rule on such an opinion. If the opinion lacks logic or objectivity, the court is not required to follow it. So, medical opinion given by an expert in the form of a testimony is only advisory in nature. It is merely an opinion. It is not comparable with the factual account which is described by an eyewitness before the court. So, medical witness, the opinion given by him is not a final word. The court will have to rule on the validity of that opinion. If the opinion lacks logic or objectivity and is contradicting with an eyewitness account, then if the eyewitness account is believable, then the medical opinion will not have any value. State of Haryana versus Bhagirath, which is another Supreme Court decision from 1999. In this case, the Supreme Court said that if a doctor's opinion lacks logic or impartiality or is inconsistent with probability, the court is under no obligation to accept it simply because it was stated by a doctor. A medical witness view does not have to be final word on the matter, and it will be tested by the court. So, a medical expert's opinion cannot be considered as a final word. So, court is under no obligation to accept it only because it is delivered by an expert, but the court will have to evaluate the validity of the statement and also have to compare with the eyewitness account or the testimony given by other witnesses. Let us see another case which is from 2008, which is Mahmood versus State of Uttar Pradesh. In this case, the court said that a doctor is a medical expert under section 45 of the Evidence Act. It is well established that medical evidence is merely an expression of opinion and is not conclusive. When oral evidence is discovered to be conflicting with medical opinion, the decision of whether to rely on one or the other depends upon the facts and circumstances of each case. So, under the evidence law, the eyewitness account has more validity compared to an opinion given by an expert under section 45. But when a doctor gives a statement before the court of course will see that statement with much value compared to any other statement. But we have to understand that an testimony given under section 45 is only an opinion, it cannot be a statement of fact. So, in that way it has to match with the testimony given by the eyewitness. But many times there would be contradictions between the eyewitness account and the evidence given by a medical expert under section 45. So, in such case the court will have to evaluate both the evidences and see which one is more reliable and possibility of accuracy is there. So, then finally it is for the court to decide based on the facts and circumstances as to rely on the eyewitness account or on the opinion given under section 45. Now, let us see another case, Tommaso Bruno versus State of Uttar Pradesh, which is a recent case before the Supreme Court. In this 2015 decision, the Supreme Court said the expert evidence is typically accepted by courts, although courts are not completely driven by experts' reports, especially if such reports are cursory and unsustainable. The goal of an expert opinion is to aid the court in reaching at a final decision, although such report is not conclusive. The court is expected to analyze the report, read it in conjunction with other material on record and reach a decision whether or not the report is worthy of reliance. So, finally it is for the court to decide whether the report is worthy of reliance or not. So, now let us see scenarios where there are two contradicting opinions given by two experts. So, let us see one case, Anil Rai versus State of Bihar, which is a 2001 Supreme Court case. In this case, the court decided that when there are two possibilities supported by medical evidence, the one that is compatible with credible direct evidence should be accepted. So, there could be scenarios where the prosecution comes with an expert opinion which is submitted under section 45 and then the defense submits another expert evidence from another doctor. So, there are scenarios where there could be contradictions between the opinion given by two experts. So, in such scenarios where there are two possibilities which are supported by a medical evidence, the one scenario which is more compatible with the credible direct evidence should have to be accepted. So then in such cases, the evidence which matches the account given by the eyewitness and it matches with other direct evidence which is submitted before the court has to be considered. Now let us see another case, Mohan Singh versus State of Madhya Pradesh, which is a 1999 Supreme Court case. In this case, the court held that in all circumstances, the prosecution story should not be automatically rejected based just on discrepancy with medical findings. The court should use its legal authority to seek out the truth. So the objective of judicial examination is to find out the truth and decide the matter. So just because there is a contradiction, an opinion need not be rejected or the eyewitness account need not be disbelieved. But then the court will have to evaluate the accuracy of the statement or of the opinion based on other evidences submitted before it. Based on this evaluation, the court will have to find out the truth and then decide the case. There could be scenarios where there is inconsistency between ocular evidence and the opinion given under section 48. So when there is inconsistency between ocular evidence and medical evidence, then the court will have to evaluate the ocular evidence and medical evidence in a very careful manner. If the direct testimony of eyewitness is credible, then it cannot be disregarded based on speculative medical findings. So if the court feels that the eyewitness account is credible, believable and it is coming from a trustworthy witness, then it cannot be simply disregarded just because there is a contradiction between a speculative medical finding and it. So as long as the ocular evidence is credible, it will have precedence over the medical evidence. So while evaluating the evidence, the court will have to see how far accurate is the ocular evidence, whether the witness is trustworthy. So in such scenarios where it is found to be trustworthy, then the ocular evidence will have precedence over medical opinion given under section 45. Similarly, a medical witness opinion need not be final word on the matter. It is merely advisory in nature. The court is not required to follow an opinion if it lacks objectivity or logic. The court will simply evaluate such opinion and come to a conclusion. So the court will have to see when an expert opinion is submitted before the court, whether it is objective and whether it is having logic. The judge has the option to accept the viewpoint that is more objective or likely in the event that two doctors have differing opinion about the same fact. So in case there is a contradiction between two expert opinions submitted before the court, which is coming from two different distinguished medical experts, then the court have to see which one is more objective and which one is more logical. And then the court will also have to see whether it is matching with other evidences submitted before the court. So the evidence that is found to be more objective, more logical and matching with other evidence including ocular evidence submitted before the court will have to accept that evidence. In a similar manner, the court is not required to accept a doctor's view just because it is stated by them if that opinion conflicts with likelihood. Of course, the opinion of those who are knowledgeable about the matter at hand must be accorded the weight they deserve. That is why the opinion given by medical experts have been given much weightage by the judiciary. But at the same time, if the opinion is conflicting with the likelihood, it is conflicting with a credible ocular evidence which is coming from a trustworthy witness, then the court will have to evaluate these evidences in a very careful manner. Let us see another case, Ajay Singh versus State of Bihar, which is a Supreme Court decision from 2000. When the postmortem report revealed that the deceased had an injury slightly higher than the thigh, despite the eyewitness testimony that the gunshot wounds were on the leg and there was no evidence to refute their account. It has been decided that the reliable eyewitness testimony would not be enough to be disregarded in the absence of conflicting opinions from ballistic experts regarding the location of these injuries. So, when there is only a minor conflict between the ocular evidence and the eyewitness accounts, then it need not be seen that there is a contradiction. But then the court will have to understand that one is coming from an expert who has got time and expertise to evaluate the situation, whereas the eyewitness account is coming from a person who has seen the incident with his eyes. So, then one need not be simply disregarded just because there is a minor conflict with another statement given before the court. So, let us see another case, Ompal Singh versus State of Uttar Pradesh, which is a 2011 decision from the Honorable Supreme Court. In this case, the medical evidence showed that there are multiple gunshot wounds, but the eyewitness gave a testimony that he has seen only one shot being fired from a double barrel gun. So, prima facie, it appears that there is a contradiction between the statement given by the eyewitness and the expert opinion given under section 48. But in such cases, it had been held that single shot can cause multiple injuries. So, as there is a possibility that a single shot from a double barrel gun could lead to multiple injuries, then there is no need to see that there is a discrepancy between ocular evidence and medical evidence, because it is possible that from a single shot which was fired, which the eyewitness has seen and deposed in his testimony before the court, it is possible that multiple injuries could be caused as given in the expert opinion. Let us see another case, which is a 2002 decision from Supreme Court, Keshavalal versus State of Madhya Pradesh. In this case, according to the first information report filed before the police, the deceased person's nose was injured, but all the witnesses testified in the court that the deceased person's body was injured from behind, close to her right shoulder, and that the force of the injury caused the insides of her body to be cut. The Supreme Court held that this discrepancy between the testimony of eyewitness and the FIR will not impact the prosecution case, because all the witnesses testified in court regarding the same injury. So, in this case, actually what happened is, when the first information report was filed before the police, then it was deposed that the deceased person's nose is injured. But when the witnesses testified before the court, they gave a statement that the injury happened from behind. So, in such case, is it possible that a person's nose will be injured when the force was coming from behind? But the eyewitnesses, when they gave the testimony before the court, clarified that it is the force of the injury which caused wounds inside her body. So, in such case, when it is clarified, the eyewitness account need not be disregarded. Let us see another case, State of Uttar Pradesh versus Harban Sahai, 1998 judgment. The word Kanta was included in the FIR, and the deceased had one incised wound on the right side of the chest. The eyewitness testified about Kanta in the court. The difference between medical and oral evidence was deemed negligible because the use of the Kanta was not ruled out. The Supreme Court ruled that the eyewitness testimony cannot be dismissed based only on the opinion of a medical expert. So, this takes us to examples where there is a possibility that the medical opinion gives details of a wound caused on the victim, but the eyewitness account, a testimony is given before the court which tells that a particular weapon was used to inflict the injury. But however, on comparison, the weapon which is mentioned by the eyewitness is not matching the injury which is explained in the medical opinion. In such cases, the court has to see whether there is a possibility that another weapon was also used. If that possibility is not ruled out, then there is no need to disregard both the evidences. Now let us see some examples of cases where there is contradictory opinions given by two different doctors. In state government of NCT Delhi versus Sunil, which is a 2001 Supreme Court case, two doctors' opinions differed. The court has authority to act on the testimony of one doctor whose testimony agrees with the prosecution version rather than the testimony of the other. So now there is discrepancy between two testimonies given by two different doctors. So now the court has to evaluate and see which one is more matching with the other evidences submitted by the prosecution. So whichever testimony is matching with other direct evidences which are adduced before the court can accept that opinion. In Pyara Singh versus State of Punjab, Supreme Court decision from 1977, when one medical witness view is opposed by another, both of whom are equally competent to make an opinion, the court should typically accept the evidence of the medical witness whose evidence is corroborated by direct evidence. So when there is an opinion given by an expert and there is another opinion given by another equivalently positioned witness, then the court will have to compare both the opinions and also see which one is more matching with the other direct evidences submitted before the court. The evidence which is matching with the eyewitness testimony or other direct evidences before the court should have to be accepted. Medical opinion on death. Medical technology has made a lot of advancements in the recent time. However, it is still difficult to accurately show the time of death of a person. But the doctor is the only qualified individual to determine the time and cause of death. In Ramswarup versus State of Uttar Pradesh, the Supreme Court said that a doctor can never be completely sure of the exact moment or extent of an injury. Even though medical technology has advanced a lot, but still it is impossible to accurately show the exact moment at which an injury or death of the victim happened. But it would be possible to show that the injury or the death has happened within a possible time frame. So in that way, the expert opinion given by a doctor has to be seen only as an opinion and it has to match with other evidences submitted before the court. In Sahebaro Mohan Bhatt versus State of Maharashtra, which is a 2011 case from Supreme Court, when the deceased wife death was reported to be from drowning, but the doctor discovered a hematoma on her neck and took into account both internal and external injuries. The doctor definitively stated in the postmortem report that the deceased death was caused by a rolling pin being pressed against her neck. In this case, it was reported that the wife's death was caused due to drowning. But however, the doctor who conducted the postmortem gave an opinion that there is another cause for the death of the person. It is due to a rolling pin being pressed against the neck. Additionally, there was evidence that the husband was present at the night of the incident, and since the accused cannot offer any explanation as to the wife's death, he had to face the prosecution. It was then established that the doctor's stated cause of death can only be disregarded if his assessment is fully flawed. If not, the doctor is the only one qualified to offer a medical opinion under section 45 of the Evidence Act. It is possible for a doctor to give an opinion as to the age of a person. Shah Nawaz versus State of Uttar Pradesh, Supreme Court decision from 2011. Only the event that birth certificate, school certificate or matriculation certificate issued by corporation, panchayat or municipality is unavailable, a medical board's opinion can be sought. It is improper to determine a juvenile's age solely based on medical board's assessment, ignoring the date of birth listed on school record and mark sheet. So, if there is a date of birth mentioned in any record which is acceptable by the court, then such date of birth shall be followed. But if there is discrepancy or if there is no such record indicating the birth of a person, then the age of a person can be evaluated by a medical board, and the opinion given by such medical board will be relevant under the Evidence Act. In Om Prakash versus State of Rajasthan, Supreme Court case from 2012, while a doctor's assessment of an accused juvenile's age is merely an opinion, it will be regarded as significant evidence with corroborative value when the opinion is supported by scientific medical tests such as radiographic examination and ossification test. So, if it is supported by, or if the opinion given by a medical expert is supported by other scientific tests or medical tests, then it is an acceptable opinion. Ossification test is the process of bone formation in human from the birth to death. As we grow old, various bones in our body undergo calcification or hardening. During these times, minerals such as calcium and phosphorus are deposited in the bone matrix. The pace of bone growth slows as the person ages, and the bones eventually become more brittle and prone to fracture. Because this process is predictable, scientists have developed ways for calculating a person's age based on the degree of bone ossification in specific areas. The degree of ossification is determined by X-rays, specifically in certain areas of our human body. To conclude, the medical opinion is only advisory in nature. It is based on a medical officer's observation of the injured person's body or the corpse after the incident has occurred. Because witnesses are eyes and ears of the court, oral testimony takes precedence over medical evidence. If the witness's oral testimony is deemed to be trustworthy, creditworthy and inspiring confidence, then the oral evidence must be believed. It cannot be disregarded based on hypothetical medical evidence. But it does not mean that medical evidence is always disregarded by the court, but it is actually the opposite. Medical evidence is always given much weightage by the court. Problem comes if there is a contradiction with a eyewitness testimony which is seen by the court as trustworthy, creditworthy and inspiring confidence. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.